on Wednesday, September 9th, 2015. And this is the San Juan County Planning and Zoning Commission. We are going to take care of a couple of minutes of housekeeping, and then we will get to the hearing that I imagine many of you are here for. We're going to discuss tonight, we're going to have a hearing to answer allegations that the CUP issued to Wasatch Wind, which is sPower, should be revoked for lack of action. And a little quick summary of what happened is, no sir, I'm not calling on the
I'm just saying it's a meeting, not a hearing. If it's a hearing, I can talk.
No, it's a hearing as in judicial style hearing, sir. This hearing is brought to us tonight by, it is brought forward because we had citizens who expressed concerns about what was happening with the CUP now that it actually evolved into building process by the issuance of a building permit. When those challenges and concerns were brought forward, this board had a meeting a month ago at which we determined that there was, keeping it judicial, there was enough evidence for us to have it answered. We need answers to the challenges that have been brought. There are only two challenges that this board can consider based on what is given to us in our code. The two challenges, as were presented to the CUP holders, the permittees, sPower, we'll just call it sPower to keep the conversation moving. The two challenges leveled to sPower that they will answer at tonight's hearing are, one is the actual timeline for what they call considerable action, substantial action. Let's get right to the wording. The allegation that there was by, I'm just going to read the two things we're going to discuss. It is alleged by neighboring property owners and competing wind power projects that the Latigo CUP shall be revoked for the failure of the permittee to perform substantial action within 1 year of its issuance or after the 6-month extension as required by our code, which is Chapter 6. The second thing that we will discuss would be that it is alleged by neighboring property owners that Latigo CUP shall be revoked for the failure of the permittee as much as possible include flicker, light, and sound mitigation to the affected landowners as the project proceeds as required by the Planning and Zoning Commission in October 2012. What we won't discuss are real estate deals amongst people who own land there, because the wind project must have permission to be on the land. That's all we can do. We cannot be concerned with the real estate actions around it. We will not discuss the idea that the CUP was issued. I'm just trying to address a couple of things that were also in the original challenges. We don't discuss the idea that it was perhaps issued illegally, because that was a process that was 30 days in the making by our code. So the two things that we will discuss will be done by the permittees, the CUP, sPower. They will present to us. There will not be a back and forth and give and take throughout the audience, because that just goes back and forth and give and take. During and after the presentation, we as a board get to question and ask for clarification to our satisfaction of those facts. What my board doesn't know, and I just found out, is that we have been advised as a board by our attorney to take this matter under advisement at the end of this discussion tonight, and that we will render a decision later. And we will render that decision in a written form to to the CUP holders. This was presented, and therefore, what we're going to do is open it up in a moment. We'll see if
Why is that not? I mean, just because he met with you doesn't mean the board agreed to that.
he has asked us to take this up.
Yeah, you met with him, right, though?
I met with him just now on my way
Why
here.
didn't he come to the board and express that?
Because he couldn't come tonight? I don't know.
That's not
I cannot tell you what to do. I can only tell you what was suggested, and that was what we were told.
Oh, yeah, I understand, but isn't that a board decision?
I suppose technically it can be, because this board has the right to act in revocation or in hearing of revocation.
But I think that power isn't for you to make that decision, is it?
I'm not making the decision. I was asked to explain that, and I just have. And if we're,
I thought Trent's original proposal from last time was that you were addressing the issues that would exist within the temporary CEP, not just the two issues. We said, was there a letter from the, I distinctly remember we asked if there was a letter from the airport, what is it called? FFA?
that's part of the
I didn't hear that
timeline.
when you just explained the two issues that were in the draft.
Because the timeline would include, the timeline, I believe, Jeff, is what you're thinking about, in that they would have had to meet so many things to get their substantial work done. I don't know. We're going to hear that told to us, and then we get to determine if that's what we needed to know.
Okay.
So you're right. If that's an issue for you, some of the permits and data, then you'll want to hear that.
It's not really an issue, just whether we got it done or not.
And that would be part of what they say. So let's listen and find out, and then, according to the request of Mr. Laws, we are supposed to take this under advisement, in which case we would discuss it at a subsequent meeting. So, with that being said, I am going to call on Greg. Do you have anything that you needed to add from procedure? Okay. And we have to add, okay, we're going to ask sPower to make a presentation on those two issues. Would you please, when you speak, address this board and identify yourself for the record? Thank you.
Okay. Thank you, Marcia. I'm Josh Scogan with Sustainable Power Group. Thanks for the opportunity to allow us to present and provide a response to these allegations. So number one, as I understand it, is an allegation that the project has not performed substantial work prior to the expiration of the permit, which was April 4th of 2014. The project considers any activities that fall under the umbrella of engineering, procurement, and construction as substantial work. That is our EPC activities. Those are activities that require a number of gating items to be completed, typically under the umbrella of development activities, prior to us even considering proceeding with those activities, because they do require extensive capital and resources to move forward. Some examples of the things we did just alone in engineering. In August of 2012, we began geotechnical work at the site. And what that is for us to determine how we are going to design these foundations to support these large machines, we have to understand what are the conditions of the soil, what are the characteristics of the underlying soil, for us to proceed with designing the foundations, designing the wind loads, and understanding the electrical conductivity and resistivity of the soil, so that we can design the size of the conductors that connect the machines. All of that's very important. So the geotechnical work that we did, we performed in August of 12, multiple holes around the site ranging from 12 to 41 feet, and brought those soil samples to a laboratory and had them investigated. And a report was done, which informs our engineers to advance the design necessary to proceed to the next step. In April, let's see, another very important piece for us is to understand what is our buildable area in the project. And in order to do that, we have to go out and perform a number of on-site field surveys. Those include a boundary survey, topographic survey, existing conditions, all which come together and prepare what we call an ALPA survey in this industry. And that survey really informs us as to where is it that we can build? Where are our property rights? Where are there existing easements? Where are there existing infrastructure? So that we can inform our engineers as a second piece to help us advance that engineering to the next step. Other studies we conducted prior to that deadline included continuing to understand what is our buildable area. And that included some cultural resource surveys on site, including pedestrian walks. And that reinforced our archaeologist desktop surveys. So that's their first step, and then they go out and actually do the field survey. And they go out and do a visual assessment, and anytime they see anything of cultural significance, they'll pick it up, and if it's significant enough right there in the field, they will take it to their laboratory for further study and come up with a report for us to tell us where are there any potentially sensitive areas that we need to avoid, or reach out to the jurisdiction having authority over those artifacts to discuss the necessary steps for mitigation. On November of 2013, the project also posted a letter of credit to Pacificor in the amount of $830,000. And what that did was allow Pacificor, as one of the very important stakeholders in the project, obviously they're not only buying but delivering the power to the ratepayers, allows them to commence their design so that they can advance towards the procurement construction stages, all falling under that umbrella of EPC work that we consider as substantial work. Under the procurement part, some examples of what we did there. The project entered into a purchase agreement with General Electric for transformers. And these transformers are all tailor-made to each project according to the specs of the machine we choose, according to the specs of the conductors we're using, which was informed by our geotechnical design. And that's a very long lead equipment material item, as long as 16 months in this industry. So it was very important for us to establish and to get that going so that we could get in General Electric's queue or their line in order for them to make sure that they could deliver on time. So under the construction piece, in late of 2013, the project also hired a local group, Clyde Olson Energy, to design and build access roads at the project property. And they did complete approximately 4,000 linear feet of access roads, measuring anywhere between 16 and 19 feet in width across the property in December of 2013. The road construction did consist of clearing, grading, compacting the roadway, and placing a compacted road base anywhere from 3 to 6 inches deep, so that improved the road, and that was the first step we need to take in order to provide our large machines access to the site and to facilitate further investigation as warranted for any of these pedestrian surveys. So those are all just very general examples of what we've done to complete substantial work, which again we consider anything that falls under that umbrella of engineering, procurement, and construction as substantial work.
Does anyone on the board have a question for this section of the information?
Question, you started your geotech work in August of 2012. How long did that process go?
The geotech work, the borings probably took approximately 30 days, and then the laboratory results takes anywhere from 60 to 90 days. And so then we would get a draft report and a final report. So all in all, from start to finish, probably about 4 to 6 months.
So you had your report, your geotech report.
August to about January, February, maybe?
I would have to quick look that up. I don't have the exact date of that report. Let's see if I can access it here.
You started in August of
2012.
What does that consist of? Digging holes? Is that correct?
It's a special machine that does boring, horizontal boring. And what it does is it takes a core sample straight down to the earth and brings that core sample up and evaluates the various strata of the soil, so that as these foundations, as you may have seen up there, go as deep as 30 feet. So we go down an extra 10 to make sure that when we put these heavy foundations on there, we understand the conditions that we're placing with that equipment.
And just to clarify, you said that happened from the 12th for the next 4 months?
The field survey, the core sampling, the field actually took about probably 30 days to complete, depending upon the weather. And then they would take those results to the lab, and those lab results can take 60 to 90 days, and then they will draft an initial report for the customer and the client to review. And Wasatch Wind probably trying to look up when they had that all done. So here, what I have it here. There was some initial testing done, and they did a revised report that we received in July of 2014. So there's some additional field activity prior to that April deadline. Sorry, I don't have that date right in front of me.
So you could get that for us?
Yep.
Well, Joe, did you have some more clarification?
Let's see, April of 2013, Southern Engineers designed a preliminary design of electrical collection system.
Mm-hmm.
And from August through October, ECI, they do it alpha survey.
That's right. What I did mention under the engineering as well is, in addition to the cultural surveys, part of the environmental surveys was avian studies. So
I'm sorry, what study?
Avian,
Avian.
bird.
Mhm.
We've done a number of on-site point count surveys to understand the migratory path of these avian species out here, including eagles and hawks. And we've taken that data, continuing to work with various agencies on mitigation plans using that information.
And when was that?
That beginning in April of 2011 and continuing through October of 2013.
Which, I kind of remember you talking about that at the presentation of those meetings. Which of these, I'm sorry, Joe, please, I don't want to
Go
break your
ahead,
thought,
I'll
okay?
come back.
Okay. Which of these studies and/or actionable things that you're trying to explain to us, which of those are mandated? Do you by the things that you'll have to do, or which are just normal steps in any? In other words, EIS and other things are normal steps when you're developing on land.
Yeah.
Some of these are required, though. What's the difference, perhaps?
An environmental impact statement, you're saying, EIS?
An EIS, geotech, avian
Yeah.
studies, which kind of are mandated and legally required, or?
Sure. Well, as far as legally required, we are not legally required in the state of Utah to proactively reach out to
Private land, I forgot.
Yeah.
Okay, hang on.
to proactively engage third-party agencies. However, the project decided to very early on, as early as April 2011, to proactively go out and do these studies so that it could bring to these agencies informed materials and surveys so that they could help collaboratively come up with mitigation plans. And we continue to do that.
Okay. And that's because it's not on public land, it's on private land,
It is.
therefore there aren't any federal guidelines that you have
That's
to
right.
meet. Okay.
That's right. But all these were very absolutely imperative steps for us to even get to the stage we're at today. because they're very long lead items.
More questions, Joe? Did you think of the rest?
So we've done you did a geotechnical survey, mid or late 2012 through early 2013, we assume.
Yeah, it looks like additional geotechnical work performed in June and July.
Okay.
June of 14.
June of 14?
Yep.
Okay.
So that would have been beyond that April deadline, but the work actually started in August of 12.
And then in April, you did your collection system design, a preliminary
That's
design.
right. And that's important for Pacificor to understand the loads and impedances of our side.
And from April through October, you did your ALTA survey. Remind me again what ALTA stands for.
American Land and Title Association.
And then September, you hired Arcadis, is that how you say
That's
that?
right. Yep.
To perform the cultural resource study.
As well as the Phase 1 environmental site assessment, which is an assessment of all existing environmental conditions that may be present on the site, resulting from, existing septic tanks, existing water wells, existing, maybe there was no gas tank on one of the fields underground, just to understand the potential liability that the project may be taking on prior to entering into these long-term lease contracts with the landowners.
Okay, then we'll go to November of 13, $130,000 worth of credit with Pacific Corp, commenced engineering on the Pinto substation. So you're telling us that Pacific Corp began this new bay to the Pinto substation at that point?
What they did is they commenced the engineering of that. That's right.
Does anybody else have questions on this segment?
Well, it's just very confusing to me how anybody could eat up this much time doing what you're talking about. We've done it on airports.
Okay, we're not going to express opinions right now.
No.
We're just going to.
No, I would just
Okay.
like to know, is
Okay.
there any
Okay.
more, could I ask how much money you've actually, okay, I can't ask that.
Well,
How much you
they can say whatever they want about money, but it has no bearing really on our
Yeah, just-
discussion.
Yeah, just.
I'm fine answering that
Sounds to
question.
me like
These
it's
activities
taken a
alone,
long-
as you can see just here,
That'd be
resulted in
easy.
well over $2 million.
Okay.
That's how the ball rolls. Sorry to say.
Okay.
That's
but-
all my question on this segment.
Okay, so the segment you've addressed then is to explain what you believe is substantial action during the time frame.
That's right.
Some of it continued, or some of it occurred in the initial period of the year plus the 6 months, basically. You had started.
Yeah, correct. These activities, as you can see, can't all be in parallel. Some of them are dependent upon each other, so they're in sequence, and that's why they're not all happening at the same time, because one piece informs the next, and so forth.
Okay. Let's continue to the next part, and then we'll come back and see if there are any specific questions to what we've heard, and maybe that'll help direct our thoughts.
Okay.
Okay.
Can I ask one more quick thing? Which company performed all of your geotech work up there?
Terracom?
Lincoln DeVore or?
Terracom?
Okay. You got her. Thank you.
Yep.
Okay, if you'd like to address the concerns we have about mitigation.
Yes, and I apologize. Can you reread the allegation
Sure.
just so I can
Sure.
understand exactly what to address?
The allegation in the request for hearing, it is alleged by neighboring property owners that the Latigo CUP shall be revoked for the failure of the permittee to include, as much as possible, flicker, light, and sound mitigation to the affected landowner as the project proceeds as required by the Planning Commission at its October 4th, 2012 Planning Commission meeting, where it approved the CUP.
Okay.
So we asked you to do the best that you could to take care of the neighbors, and we'd like to know what was done.
Right, it just says in there landowner, so am I addressing one?
No,
individual?
it's interesting because it's sick in parentheses,
Okay.
as in perhaps typo.
Sure.
Landowners.
Yes.
We're talking about a lot of people. So.
Right. Okay. So specifically speaking to, let's start with sound. So on the sound, as you know, the county of San Juan did not have a sound standard or any sort of enforced sound limits. So what we did is we hired a third-party professional who has well over 20 years of experience in sound study, J.C. Brendan and Associates. And what they did during the supplemental statement is come up with a set of proposed sound thresholds that the project should adhere to. And if the project was unable to adhere to those, there was a set of mitigation requirements set forth. So we have continued to incorporate those sound standards in our design. We actually just recently completed an updated sound study based upon the planned turbine and their final locations. For existing residences, the project does not exceed, actually comes very far from, even coming close to, the thresholds for existing residences. As you know, most of the existing residents are well east of the project and will not. I think the loudest one for an existing residence was around 37 decibels, and the threshold was 47, I believe.
You're saying 37 is what the turbine will generate?
Right, 37 decibels. I mean,
At what
to put it in
distance?
context,
Yeah.
the sound of your refrigerator in your home can be as loud as 55 to 60 decibels.
So where's that decibel reading taken at what distance? From
Right. So how they do the study, that's a good question, maybe I should step back. The way they perform the study is they assume the very loudest sound output level that the turbine can produce right at the turbine spot.
Okay.
And then they set up a number of receptors around the site. At this site, we set up 11 receptors all around the site, anywhere from locations nearby existing residents all the way out to west by the federal lands.
Okay.
And those receptors studied the ambient sound to have a baseline. And then they put it in a model, which is a very widely accepted industry model and methodology for analyzing sound. And with the specs of this machine, they have what they create sound contours based upon the direction of the wind speed, the prominent wind direction, a number of variables that these engineers put in these studies to understand what is the potential sound at these receptors. And they come up with these sound contours and they interpolate in between. And what it showed was that the project does not propose to exceed, it meets or exceeds the requirements, I should say, for all existing residences.
When was that study done?
It was just recently issued in August.
Just a month ago.
Mhm. Because we knew that this new machine was a quieter machine. And the conclusion of the report said just that.
Okay.
From what was originally included in the, the October application. For nearby properties, let me just take a look here. Make sure I don't get sound and flicker messed up. Okay, so for neighboring properties, there is one parcel located at the northeast corner of the project site, just outside the project boundary, where the sound contour for vacant lands was exceeded on a very small portion of it. But however, the greater acreage of the property was left undisturbed and meets or exceeds those thresholds. So what we're doing is reaching out to that landowner and employing the mitigation measure to provide that landowner with $4,000 for the installation of additional insulation or other soundproofing solutions to mitigate the potential turbine sound impact, which is per the supplemental statement and CUP condition.
So this is one adjacent landowner, you've offered $4,000 for him to do his own mitigation or something that?
We would absolutely cooperate, and that's not, we're very collaborative. One example of this is the study takes a look at, that's the flicker study. So I guess I would have to transition to flicker, make that's the right time. But the flicker study takes a realistic case, which incorporates the direction of the turbine and where the wind's coming from. It assumes that the turbine is always blowing when the sun is at that perfect angle, reaching that perfect turbine, and the shadow hits that house. Then there's a worst case, which assumes it's a very conservative estimate, and it assumes that there's no cloud cover, that the turbine is always facing perpendicular to the house, and it's rotating at that perfect time. So the stars kind of have to align for that study. But that worst case scenario did show in one instance, there is one existing business in the area of the project that we exceeded the flicker threshold. And the mitigation requirement, again, in the CUP was to provide them with $4,000 for mitigation, whether that was for trees or for window coverings or whatever it was. But we went above and beyond and provided it was the Discovery School, and we have provided them with a commitment to do $250,000 over the next 5 years to fund a number of their programs, including educating not only the valley here, but well over into Colorado about renewable energy. So if that landowner was unhappy with the amount of trees we planted and they needed a few more, absolutely we'll work to make sure everybody's happy in the project area. And we've continued to work with everybody.
When was the flicker study done?
The updated flicker study was completed in August of 15 as well.
Were most of these updated because you were using new equipment and wanted the new answers?
Exactly.
Had you done basic flicker and noise studies from the beginning?
Yes, that was all. There were 2 iterations of the flicker and 2 iterations of the sound study prior to this that were submitted as part of the supplemental
Yeah,
application.
okay.
And that was all reviewed and incorporated and discussed, incorporated, as I understand, into the conditional use permit. And these measures to provide $4,000 as part of our mitigation requirements if we ever exceed the thresholds. And then for sound, on the non-participating in-holding landowners, there's about 80 acres comprising 9 parcels adjacent and within the project boundary. And because of the quieter machine, we've actually reduced the decibel level, the recommended decibel level, was exceeded on 2 of the 9 parcels. I think prior to that, it used to be 6 with the last machine. And we've actually reached out to two representatives, and we're in active discussions currently with that group representing the non-participating landowners to work out mitigation. We've certainly offered the $4,000, but we've offered a substantial amount more based upon the appraised value from a third-party appraiser, and offered that as compensation. We understand that the non-participating inland landowners had worked out a mitigation agreement with the previous developer, Wasatch Wind, and received some proceeds from that. That agreement has since expired. It was never exercised. But we continue to work with the representatives from those landowners to mitigate any potential impacts from sound, flicker, or light, or sound, flicker. What was the other one?
Sound, flicker, light.
And light.
No.
Yeah, light. Light. I'll get on that.
Okay, sound, flicker, light.
So on shadow flicker, again for existing residences, the only property that was had a predicted exceedance of the thresholds was the Discovery School, and I've talked to you about the mitigation that was done with them and actually signing an agreement memorializing that commitment with them. For non-participating adjacent landowners on shadow flicker, look here. Of course, that was addressed specifically in conditional use permit, conditional approval number 4. So the shadow flicker is predicted to exceed portions of 4 of the 9 properties during a realistic case, which isn't the conservative case, it's a very real case. This is again a reduction from what was stated in the supplemental agreement because of the shorter machine. We've actually reduced the machine height by 30 feet.
The tower height.
Tower height, correct.
Okay.
Again, so per the mitigation requirements of the CUP, we are to reach out to that landowner and offer up to $4,000 towards consultation with an expert to orientate the windows in a future home, to purchase opaque window treatments, or plant trees to mitigate the potential shadow flicker impact. Again, there is no existing residences on the 80 acres of the non-participating inland properties. That group has expressed an intent to develop residences there in the future, and if they ever do that, we'll certainly honor this condition of approval. The second part of that is that we are to provide them with a payment equal to any unmitigated residual property valuation loss based upon proximity to the project park. And then the condition of approval sets forth the process as to how that's done and includes an appraisal process. Again, we've taken that step. We've presented that appraisal to the representatives of the 9 parcels, and we're currently working on that together. And then on light, the project regarding light, there was a specific requirement to do dark sky compliance. That is not an industry-defined term, but we did see some references to it, and what we did is comply with the mitigation requirements of those references, which were to make sure that the lights could be turned on and off manually by the operators as they go up to the substation. So the only place that will have regular light bulbs is the substation, for obvious reasons. And those lights will be turned in a downward face direction, so they won't be facing up towards the sky or out towards the road or towards any residences that we face them directly down, so the operators can perform their work in a safe manner. The second part of that is that per the Federal Aviation Administration, we are required to light the towers for air safety. Anything above 200 feet is administered by the federal government. And these machines, as you know, stand higher than 200 feet, so they have to be lit by a light. And what we did is work with the FAA to employ the minimal amount of lighting required for a project of this size. And they did approve that based upon the final design, so that's all done. And those approvals, I think, were back as early as 2013.
Are we talking what we picture as the red light?
That's right.
Okay.
Yep.
So those will be on all the time?
No, they will not be on all the time. They do flash. That is an FAA requirement. But they flash. It will not be on all 27 turbines. I don't know, Sean, you know.
I think it's about half the turbines.
About half the turbines will be on. And that is the absolute bare minimum that the FAA will agree to.
No, I assume that it's towers scattered through the project. It's not just half of them in the others.
That's right. It's kind of a perimeter, kind of like if you're on a lake and there's a rock pile, you have buoys around the rocks.
Go ahead, sorry, we stopped you.
Nope, that's fine. That's all I have on lighting. Sound and shadow flicker, I think I've hit the points that I wanted to hit. Are there any questions on that?
Does anybody at the board at this table have questions for this section? John? Okay. Joe, you seem to...
We're talking mitigation here.
Okay.
I don't know if this is here or in subsequent.
Okay, just if it's
sections.
a
One of the conditions of the original CUP was that tower number 10 was to be moved.
oh, okay.
Was
Then it
that
was.
done?
It was. That was shown and illustrated in, I think, one of the exhibits of the supplemental. And we adhered to those locations, which was referenced and complied with as part of the building permit package.
As part of your building permit application, did you have a layout?
Yes,
Of
we had a
the
full
tower.
construction plan set.
Is that right, Greg?
Or if I move.
Okay. Couple, or coming back to the conditions of the CUP and the amended one or the extended one. As much flicker, light, sound mitigation as possible. Including all new information along with new leases and any mitigation to affected landowner. And must be met by the developer, whether now or in the future by the present developer or future of a different developer. And prior to any building permit being issued. My questions to this point.
Okay, to
We
this
can
point,
go
that's
on.
fine.
I'd like,
Yeah, I think a lot of it could just be summarized on sound and shadow flicker. We chose to go with a quieter machine than what was planned in October of 2012. We've also chosen to go with a shorter machine than was planned in October of 2012.
How tall is the machine now?
80-meter hub height and 116-meter rotor.
Would you say that in American?
In American, yes. So that would be about 260 feet hub height. And that would be about 350 foot diameter rotor.
Okay. Couldn't imagine why this is all written in meters.
Yeah.
We don't speak meters.
Especially their U.S. made machines and blades.
The only other job like that is archaeology.
Yeah.
Centimeters, you know, it's like, what? Okay, more questions for mitigation. Gentlemen.
Are you gonna present any more on what you've done to make substantial progress?
Joe, do you think you have specific, I think you've presented what you feel to be substantial, so.
Yeah.
I'm just looking at the letter that you wrote, that
Yeah.
you've got a copy of it. Do you want to address any of this procurement or construction issues?
Well, you kind of did, I thought. GE purchase was procurement.
Mhm.
The access roads were construction, but those were a little bit late. No, those started in 2013.
Mhm.
Um,
Yeah, again, we consider anything that falls under the umbrella of engineering, procurement, construction as substantial work. And that letter just illustrates some of the examples of what we've done in each of those categories prior to the expiration date.
And we, my name's Sean McBride, by the way, with sPower. We tried to really outline the work that was done prior to that 18-month period of the CUP. You'll see that on some of those, there's like a follow-on, like geotechnical work was performed during these months, and then there was additional work, and then some of those follow-on items were after that April timeline, so we put that in there, just a little bit of, to kind of show a continuity that was done.
Mhm.
There were many other activities that were done after that April timeline, but we weren't trying to give kind of the overall schedule of the whole project. We'd be happy to share that more detail if you want to see kind of the broader timeline after the 18-month period, what's been done since then. But we thought the relevant time period was really that 18 months.
And it is, and that's what we're addressing right here. I think one of the points that you've made about that, however, is the continual aspect of it, because much of it has to lead from one to the other. I think that's
That's correct.
part of what you're emphasizing here. You can't start one without finishing another,
That's
sort of
absolutely
thing.
right.
I
Very
think that's
sequential.
what's helping, would help me fill in some gaps there, is when you actually receive that, the final geotech report.
That's where I'm a little confused is when the study started, because I think that was, the intent of what we asked for was to have those cleared before that building permit should have been issued. Is that not true, or am I?
I think to the extent that it could be, yes. I mean, I know what you're asking, and therefore it may behoove you to take a minute when we take a break here
Yeah,
for a second,
sure.
to at least maybe find some timeline answers for the gentlemen that are,
I mean,
to ask how
to me,
to do it.
that's just the only issue is the clarification of that time frame.
Okay.
If we just barely did the bird study in July, I don't think that was the intent of the board. We wanted to know the bird study was happening at the time.
or the studies were.
Yeah,
Right,
and I think
okay.
on that timeline, you'll see that that is the case. One of the main things that we had to complete the geotechnical study for at that time was the transformer. The transformer is a very large piece of equipment that sits on a concrete foundation. And for us to collaboratively work with the vendor of that transformer, they have to understand where they're putting it. They have to tell us what their load is. We have to reiterate whether or not we're ready and willing to provide the platform to host that piece of equipment. So that's all very important in those early stages.
Well, that's
Part of
changed, hasn't it?
The transformer,
Where it's going? Didn't you move it?
the substation.
Uh-huh.
I'm not aware that it's been moved. Not substantially so that it would. The soil, as we saw across the site, is very
Similar?
similar, very consistent. And we're experiencing that right now. We just talked with some of the contractors prior to the meeting, and they have about 7 of the foundations poured, and I think about 10 probably dug, and they're experiencing very similar conditions in each one, as expected and informed to them through that geotechnical report.
More questions? Gentlemen. Steve? Does the board feel like they've been given enough information to bring it back to the table? Okay. There's still something that's,
Something in
there's
my craw
something,
here.
okay, okay. I don't want to cut off the idea that we need the information to make the discussion go.
I guess I still come back to the amended CUP that we did in October
Yeah.
2012.
Is there a certain,
Yeah, I'm
condition?
just reading here that there's something here that's not quite, I'm not sure we've addressed. Flicker, light, sound mitigation. On new leases and any mitigation to affected landowner.
What is it that you think is not
Who,
answered?
I guess I'm to the affected landowner. Are we talking the landowner of the property on which the house sits? Or are we talking about adjacent to it?
I believe at the time we were thinking adjacent in as much as those were the people with concerns more than the people that had leased to use their land. So I believe our intent was to say, but I'm sort of hoping that and believe that our intent was, please be good to all your neighbors, obviously.
Well, I guess that's.
And I can give you our view of that condition is when we talk about the affected landowners, it's the landowners that when we finish these studies for the sound study and the flicker study are shown to be in the areas where they're beyond the threshold, right? So we talked about the school. In the flicker study, their property was within or above kind of the threshold level. And so they're an affected landowner, as well as some of the adjacent in-holding properties, where we had, I think it was 2 of those properties that were within the threshold, or above the threshold for sound, and 4 of them that were above the threshold for flicker. That's the way that we are looking at it, and that's why we've engaged with
So you're
those
addressing-
landowners to try to.
So far you've
Provide.
addressed flicker, light, and sound, right?
Right.
And then there's this nasty word down here in the meeting for minutes that says, new leases and any mitigation to affected landowner. I guess that any throws in my mind, throws a big monkey wrench.
Well, but those are the issues, if you will, that would need mitigation. There wouldn't be anything else that would need mitigation. Any in my mind, I know what you're saying, the definition of the word any, but in my mind, I think we're asking that any of those issues be addressed to the landlord.
The light, the flicker, the sound.
Because those are what would affect the neighbors, as it were. I think, I know what you're asking. What?
since the October hearing, the project trespasses, if you will, or impacts, is predicted to impact fewer properties than what it was proposing to do back in October. So we have continued to work to reduce impacts to non-participating adjacent landowners.
You say you are in negotiation with the local landowners to reduce.
We are. We actually just had another phone conversation today, talking further. So we're very actively involved.
Email exchange today. We didn't
Email exchange.
talk with them Friday.
Correspondence.
Yeah, we've had correspondence today. We've had continued correspondence, and the way that we're approaching it is the way the conditional use permit establishes for a formal appraisal process. We had one appraiser that had already looked at the property. The appraisal treated the property as 1 8-acre block, which was not the right way to look at it. So we've actually commissioned a new appraisal to look at it with the individual lots.
Okay.
And so that's where we're basing values for what we believe are appropriate mitigation.
Well, we won't discuss values with you, but.
No, I understand, but I'm
That's
trying to let you know,
fine.
we're trying to,
Okay.
the CUP did establish a process for that. It talks about a formal appraisal process, and that's what we're going through.
Okay, any more questions for the presenters, gentlemen? Thank you very much,
Yeah,
Josh
of
and
course.
Sean.
Thank you.
Thank you. I'm going to bring it back to this board for discussion. I'm going to suggest to you that there was a request made. Jeff, you can absolutely discuss your point of view. There was a request made to us by our attorney, Mr. Laws, that we take this under advisement and come to a decision based on, or to be written and given shortly. And the shortly would be Greg calling us all and getting us to make a decision. Jeff, your take on that?
Well, I think it's a collaborative decision, though. I think it's, have everybody express their own opinions and then they set off of that.
Well, we'd have to do it as a board. In other words, if we're taking this under advisement, we step away from the evening and finish tonight, and then meet again to make it happen. Because yes, we're not going to just go home and call each other and go, oh, that was nice. We'd have to meet again to have the discussion based on what we've learned. That's exactly what I was asked. I understand your consternation in terms of what is being said, but I was asked to present that.
We have an action item. We'll vote on it.
Vote on the CUP. Is that what you're saying?
Well,
It is an action item.
I mean, is there a way, I guess, based on what we've heard, is there a way to have a timeline that I can identify, that I can, I'm sure the rest of you identify the intent of what we asked for and the criteria that was met?
If I understand your question, can we discuss this tonight based on what we just learned and decide? Yes, no, that's not what you're asking. I'm sorry. What do you-
I'm saying, kind of like what Joe's done is he's kind of tried to lay out a timeline to see if it was
If
met.
it answered, right.
If it answers it, and that's what I'm saying, that it's simplified. We say we wanted this, you know what I mean? And kind
Did they do it?
Did they do it? Because in my mind, there's a few, I mean, I want this, the words to work, I want it to happen, but there's a few questions I still have. Was there a letter from the FFA, or what's it called?
FAA.
FAA. Then they met that requirement. I move on.
Well, okay, just a second.
Yeah.
If we ask for specifics, which I thought I asked you to ask them, but okay, if we ask them the specifics, then yes.
You said you'd address it when I asked you that. It wasn't addressed, so.
Well, that's why I said any questions. Gentlemen, did you get a letter from the FAA approving this?
Yes, we did,
Do you
prior
know-
to the April 4th, 2014 expiration of the CUP.
Okay.
And can I,
Yep.
if I may, the CUP required substantial work prior to that deadline, but there's no definition as to what constitutes substantial work in the CUP, so that's why we tried to lay out what was done, the amount of money that was spent, and the conditions like the FAA conditions, like these sound studies, like...
Well, they know what was in it. All I'm saying is provide that, say it was done, and I can move on. That's all I'm saying.
So
Yeah, we can provide you with the correspondence with the FAA.
Okay.
We're happy to do
FAA
that.
correspondence was before what? April?
Let me
Okay, see if you can find a few dates while we...
find you.
All I'm saying is we put the list out in October, right?
Right, and in October 2012, they
Right.
had, and then they, okay.
So that's all I'm saying. Is that if it was met, it was met.
But can I say, I think there's a difference between the conditions in the CUP for all these things that we've been talking about
Right.
tonight, and the timeline for work to start before the CUP would expire. Because, for example, the FAA, although that's a critical component, and we did get it in that 18 months, it wasn't required in the 18 months.
No, but it was required before it was supposed to go for the building permit.
Oh, I didn't think the building permit was at.
We put the
Discussion.
criteria, I thought, that we wanted to see these things completed, and if they were, then they would we'd go right into the building permit. Maybe I was mistaken, it was a couple of years.
Well, it was completed, so I mean, we can
Yeah.
provide it to you, but I wanted to make sure we weren't
Okay,
addressing a new issue. We're happy to address the building
right,
permit
I
issue. I just think that
understand.
was
I
on the
understand.
table
And
for discussion
we're
tonight.
not addressing the the building permit this evening, but it is, I believe, under advisement.
I'm using the FAA as an example is all. I'm not
Right.
saying that's,
Sure. No,
that's not the point.
totally
I'm
fair.
just saying, I'm using those criteria as an example of
I-
that. And really, that's the only thing we can base it off of, right?
Right, I think I understand, Jeff, that when we sat here and listened to presentations by the wind farms, we had 3 that summer or whatever, we learned a lot about what to ask. Did you have this? Will you have this? Will it be safe? Will it be mitigated? And we sort of generally said, meet all that. And I agree with you that we expected that to be complete as you go through the process, including building permit and stuff later. What we're addressing for tonight is that timeline, and does everyone at this board feel like they've met the timeline requirements, FAA, et cetera, being part of that? It appears they're saying they have, and with some of the dates in question, you
I
know.
would like some more information.
Okay, we might give them a few minutes and come back to that
Yeah,
because,
the FAA was issued September 30th, 2013.
The geotech is still my biggest concern.
Okay,
I
geotech
think
is-
it has a bigger bearing. I'm seeing a bigger potential gap there, so I'm not,
Of when it was completed?
yeah. So
Well, but the work was done on the site, starting
Right.
in.
Yeah,
August.
and I understand that, but part of that process is the geotech isn't done until you've got that report in your hand, and that's I want to see the date on that
Okay.
geotech report.
well, and we might want to be careful, and I'm not saying that's wrong, I'm just saying be careful to understand work time. You know as well as anyone that you can order something and do something physically, the results of which won't be
Well,
necessary.
and that's why I'm saying it.
So,
The geotech report, I'm in the business. I
Yeah,
know.
right,
It
yeah,
takes a while
yeah.
to get there.
right,
So I'm saying between the time you did the first borings until you have that report in your hand, what's the timeline? Yeah.
right. Okay. If that has,
It's private property. We can only say if they were met, go at it. I mean, I don't think we can do anything else, but
we are authorized to have this hearing and make a determination of revocation or not revocating the, non-revocation of the CUP. That is correct. So I'm reporting at this point that we were asked to take it under advisement. I completely understand the other side of that discussion. Gentlemen, any other comments or questions as we come to this? They're both studying their pads here, trying to find a date, but go ahead.
It's my feeling we can't make a determination until we fill in some of these gaps. So.
Yeah.
What gaps?
Geotech report 1.
The questions that I had on
Okay.
beginning and completion of some of these studies.
I have the date. On this one, the timeline that I previously referenced is based upon what we're experiencing right now on some updates on a different wind farm. This one, the report was issued September 14th, 2012.
So it took about a month.
Yeah, this one took about a month.
Okay.
Well, I don't care what happened on the other one. We're
The other wind farm.
Yeah, and this one has full log reports.
Well, and I
yeah,
guess
quick lab results.
Not to disagree with Joe, but I see substantial work being taken place, the geotechnical starting in August of 2012. The report is less important to me than the actual work being done.
Well,
It's a
I
two.
agree. I mean, there's work going on, and I understand that perfectly, but to nail it down to a rock solid case, when was that completed?
Yeah.
Because it is part of the process.
Sure. But in my opinion, I see that, these gentlemen have, just to me, I see that substantial work has been
Well, there's no question that substantial work's going to be completed. I think the CUP says continuous, and that's what I'm trying to.
Actually, it doesn't refer to continuous.
No, it doesn't.
I think it does.
The actual code you're talking about, the
No.
granting of a CUP? Unless there is
I think
substantial
it's in-
action
And
under a
regardless, I
conditional
think
use
we can-
permit.
The timeline shows that, but just to,
Okay, let's not get into a back and forth here. We want to, the actual code, 6-9 is called substantial action required unless there is a substantial action under a conditional use permit within 1 year of its issuance, the permit shall expire. The planning commission may grant one extension up to 6 months when it is deemed in the public interest. So the work began and there was an extension is kind of how I see the timing in that. So,
But we have not addressed continuity, but we're happy to do that because there has been a continuous.
Well, I guess that's what's kind of driving me.
Sure.
Has there been the continuous flow of progress? Hasn't been a flurry here and then 6 months and nothing happened.
well, and I think we talked just a little bit about that. I'm not saying right or wrong, that some of that flurry is you do drill for a while and then you may have to stop, get the report, and know where you're going to drill.
Well,
That's
but
kind of thing.
That's what I'm saying.
Yeah.
That is part of the process.
Right. So, and it appears, I'm not, like I said, I'm not saying right or wrong, it appears they're saying they were working on so many various.
I guess that's what's my concern.
Okay.
is that
Okay.
The challenge has been that they're
That's
Part of
it.
the challenge is that it went from one company to another, right, as well?
No, the part that has sort of nothing to do with it in as much as everything says any owner that buys or sells will comply with the laws, our laws, every law. And I think it was explained way back when by one to all three of them that they weren't the ones going to build it. You know, they made presentations.
So we did acquire the project in June of this year. And so if there's any hesitancy in some of the timelines off the top of our heads, it's because we weren't involved.
I
During
think
that
that's what I
time.
was saying, but.
Yeah, and so
I'm sorry.
we've put together these materials in connection with Wasatch Wind, who was the original developer. And so we've studied up on these things and read all the reports to make sure that we can present a fair case. But, you know, we weren't involved in the,
Okay, I'm sorry.
in the
You
day-to-day
meant
during
the
that time.
Okay. You know who did it, okay.
I'm thinking my questions now are going to be with the county building department. I don't know if that's part of this or that's what we need to talk about later.
It is not part of this discussion per se, and it is in fact,
Let's talk about that in the next meeting.
I know. So what I'd like to know from the board, thank you. What I would like to know from the board this evening is, would you like to stop at this point, take it under advisement, and set a time to meet and get this done? Because supposedly we will have answers in the next 24 to 48 hours. Or do you wish to proceed as you pointed out? I would like to know from the
I
board.
would like to take time and study it and then come back and have another meeting.
Well, that's, okay.
Do it next time.
Pardon me? John, you seem to be,
So are we talking
Another one.
another month? Are you talking
No.
tomorrow meeting again?
Well,
What are you talking? I don't understand.
I was told by the county attorney that we should have answers in the next day or so that we can meet and make a decision. However, we have the power to make a decision because it is the Planning and Zoning Commission that does. So if they have answered the questions to your satisfaction, and that's where you stand, I understand that.
Did they ever provide any kind of an overall time frame or timeline, like most projects that Joe and I do, you have to provide the owner a time frame from beginning to end.
I don't think so.
Did that ever been a requirement?
We didn't
No.
require it.
That's not a
Well, then
requirement.
how would we?
No, because that's not our question. Our question is not the timeline of the project, it is what happened on the ground, or what happened as substantial action during the dates in question.
So all you're worried about is whether they got substantial action or investing money and moving
No,
forward.
not investing
Well,
money.
whatever substantial action, and, you know, I guess you could call, they're driving down here and walking around the project and so on. Not substantial action, if you wanted to. But I'm just, I don't even care what they've said or anybody else. I want, what are we trying to do here? Are we just making up our mind whether we're gonna revoke their permit?
Yes.
Which probably wouldn't carry any weight anyway, because the county commission was will override it.
No, they cannot.
Okay, that was my question.
I think, I was just gonna answer this question. I think that we're just trying to decide if they met the requirements or not. That's the
Exactly.
bottom line.
So that's all we have the authority to do, and we do have that authority.
I say we get the, I make a motion, we get the information, wait, and then have our meeting. Because I don't know what information is supposed to be coming in. Is that to you from the county attorney or with internally with us? What does that mean?
County attorney.
Is there a-
He's waiting on an answer. He asked me to say that. I said, okay, I will say it. I was driving and talking on my Bluetooth and said, I can't do this, so we met in Blandon for a minute. Phone texting, but my car does text also, so my car's smart.
I'm gonna just say this, I've been
Wait a
provided enough
second, we have a motion
information.
on the table. Does anyone wish to second that? Motion dies for lack of a second for the moment. Wait. The motion was to wait for more information and have a meeting and make a decision.
I'll second.
Okay, there is a motion and a second. Now discussion of that. Go, Trent.
I've had enough information provided tonight.
Okay?
Are we gonna meet within the next day or two, like you said, or are you
Can you?
talking about
can-
next month?
Can we get this done? I'd really like to. As soon as Mr. Laws contacts Greg and says, go for it, are you guys around for a little bit? Because it can happen quickly. All right?
My thought is we've had a geotechnical study started, and we're just waiting for the results, to know when it was completed.
Oh, he just told us. September 2000.
No, that was another study,
Oh, I'm sorry.
We still don't know when the geotech,
but it was started.
No, that was
No,
the geotech.
that was the geotech.
for this project.
Yes.
In one
August-
month?
Yes,
Yeah.
they were just as.
So the study I stated earlier was based upon the experience we're currently going through.
For the
He was
timeline and how
confusing
long
his
it takes.
time.
Yes. And it's a typical timeline, but on this project, we got results back September 2012. Including
So
all the
you-
log.
Very, so
So
30
you
days,
started
back
in
30 days.
August.
That's right,
And we're done by
September.
September.
For the geotech. Yes.
We don't have very complicated dirt.
Pretty much, or they
We're on
were
the-
having a slow August.
Okay, okay, guys, let's keep it on. Okay, so you're saying what? That you do want to make a
I've got
decision?
enough information.
Okay,
I've still got one
what's,
question.
which is, nothing you can ask me? So ask the question of us? I'm not sure.
It's with the county building. That's what my question is. Was the building permit issued with property? That's what I want to know.
But that has nothing to do with the issuance of the CUP. I'm not saying not to stop, I'm just saying we have to be careful that we're concentrating on the CUP and that the building permit issue is or is not an issue separate to us, okay? So if we were to vote to revoke, that would stop the building permit, obviously. If we were to vote to let it go, the issue of the building permit would be addressed separately. I would believe that that's possibly what's under advisement at this point, but I don't know.
Well, okay, let me go. I'm still going back to our notes from.
Okay.
It says the conditions of this CUP will be met before
Correct.
a building permit is
Correct.
issued. My question to the county building department, did you,
Well, Greg is sitting right there.
were you satisfied when you signed that permit or passed it on to the county commission for the approval, that those conditions have been met? So that was prior to, so Bruce is the one that issued it.
That application was signed by Bruce Bunker and the county commission.
Okay.
Bruce then retired, and after an application became Bruce, we fill out, after the application came Bruce, we do two separate sheets of paper.
Okay, so there's an application that the county commission approves, and then you issue the permit based on that approval of the county commission.
So the building permit was presented to Bruce,
Okay.
Bunker looked it over, he took it to county commission, they signed it.
Do you still have a copy of that application?
That was in our
Is it
last,
fair to ask to?
it was in our
see
last
it?
packet.
The application?
Yep, but
It's kind of
I,
hard to read,
but I,
but it's there.
oh,
It's the one
It's the one that said 90 meters on the tower, right?
No, that's the actual permit.
oh, just found this.
Guess I don't have a
Where's
copy.
the application?
I don't have a copy of that.
No, let's see, was the one. I thought we were given it last time. Oh, San Juan
That'll
County.
go in right there.
That's the
No, that's
permit
the-
itself,
that's the
and that,
permit.
not the application, you're right.
So, yeah, I don't remember seeing the
Okay.
actual application.
Okay, we have a motion on the table that says Jeff moved to wait for the answers, Joe seconded. Let's move on that action. So, all in favor of waiting, and what we would be waiting for then is Mr. Laws to contact Greg and say, here's the information, and us to meet and finish this. And sooner the better, absolutely, we can't drag this on. So, that is the motion and the explanation. All in favor of the motion, aye.
Aye.
All opposed?
Nay.
Nay.
Okay. So it's,
Are you voting?
well, I typically do. I was waiting to see if it was a tie or anything, anything different. But I vote to wait, so it's 4-3, I mean, 4-2. Yeah, I'm counting, I wouldn't have to wait to count to. At this moment, we are going to take this matter under advisement. Greg Adams will be the focal point here in terms of when he hears from Mr. Laws, he will get this board on the horn. We will meet short and sweet and hopefully get it done immediately. Yes, sir?
Possible date.
Tomorrow,
Won't
to
have
get this done,
Let's see, tomorrow is Thursday.
we can meet and drag our feet for another.
Well, we don't know if it's tomorrow, just
I
because we
know,
have
we
to
can drag our
just,
feet.
I kind of,
Now, is it a public meeting the next time?
It would
we
be a
meet?
public
I think
meeting.
You have to if you're all
it has to
together.
be a public meeting because
Yeah.
we're, and it
All of
would
our
be a
meetings are public.
all our meetings are public. There's no closed meeting that falls under this category. This will be a public meeting. Greg will set it up, and we will sit here and vote on the recommendation of our
We're just basically trying to make up in our own mind and amongst, as a board, whether they've met their obligations.
That's correct.
Basically all we're doing.
That's correct. In the proper time.
And And if we're gonna do it in 48 hours or real quick, like you've indicated needs to be done, you're gonna meet tomorrow or next day, because then we got a weekend.
Well, we just have to wait to hear if Mr. Laws has the answers that he projected. I don't know.
All right.
You keep saying Mr. Laws is gonna have some information, I'm confused.
That's what I was told.
And is he gonna contact me?
I darn well hope so.
If we have
I'll
supplemental
take care of
information,
that.
there have been a few requests for some additional dates. Should we?
You can feed those through Mr. Adams and Mr. And Walter Bird as you have been in terms of whatever, because one of the things that happened is in your notice of hearing, it said you could not contact us.
That's right.
And I've expressed that to the neighbors as well. They're not contacting us
That's right.
because so let's keep it that way.
Great.
And go ahead and do that. Thank you, ladies and gentlemen. It's 8:30. We're going to take a 2-minute break to let you all go, and we'll go from there.
Marcia,
Yes,
if
Kelly,
it's
I'm
a
sorry.
public meeting, you have to advertise for 24
24 hours, that's true. Is emergency can be less than 24, but we can't quite be emergency on this. So you will know that it's happening, and Kelly and Greg will know what's going on. Thank you very much, ladies and gentlemen.